All right, so welcome to the Data Practices Potpourri webinar with Data Practices Office. Thanks for joining us today. The Data Practices Office, we're a small office in the Department of Administration. We're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and providing legislative assistance and training. This PowerPoint, it's posted on our website, so if you aren't able to download a copy today, it's on the page where you registered. We also record our webinars, so if you miss part of today's webinar or you want to go back and watch it again, or find one of our prior series, they're all posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we will have another slide later with more information on accessing those resources after the webinar. So if you'd like to download a copy of the PowerPoint right now, I am going to share a file for you to download to your computer. You should see a pop-up window on your screen. You can select the file and download it to your device. If this doesn't work for you, I know some folks have had issues downloading the files in the past. Please just visit the webinar page on our website where you registered. You can scroll down to the very bottom of the presentation of the page, and this presentation will be available for download. So for today's webinar, it's another installment of Data Practices Potpourri, where we highlight some of the questions data requesters and government entities have raised in the past month or so. We are going to leave some time for a question and answer session at the end of the webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. Make sure you choose all panelists when you send those questions in so we can be sure to see them, and you can start sending those in anytime and we'll just answer them at the end of this presentation. Okay, so question number one, does the licensing data classification in Minnesota statute section 13.41 apply to licensed individuals or businesses? So Minnesota statute section 13.41 governs licensing data, and whether that section applies depends on whether the government entity is a licensing agency. Subdivision 1 of 1343 defines a licensing agency as any board, department, or agency of the state which is given statutory authority to issue professional licenses. So in other words, section 13.41 applies only to state entities that issue some type of professional license. The classification in this section, they're private or confidential, which only apply to data on individuals or living human beings. So section 13.41 does not apply to data that are not about individuals, such as data related to business licenses. The section also does not apply to licenses issued or maintained by political subdivisions, so cities or counties issuing things such as animal licenses or rental property licenses. Okay, our next question is whether a government entity can charge sales tax on copy costs. So sales tax is not permitted on copy costs. I've cited a rule on the screen here and a couple advisory opinions. Minnesota Rule 8130.9300 subpart 2 states that if a law or ordinance requires a government entity to furnish copies of documents held in its files, the furnishing of those copies is a government act or service and shall not constitute a taxable retail sale. So the Data Practices Act requires government entities to provide copies of government data in response to data requests. Based on this rule, the entity shall not charge sales tax on the fees. The commissioner has discussed this and provided an analysis of this rule and the application to copy costs in the two advisory opinions listed on the screen here, which are Advisory Opinion 95-053 and Advisory Opinion 09-018. And you can access those opinions through our advisory opinion search on our website. Okay, our next question. When is a juvenile considered delinquent for purposes of Minnesota Statute Section 260B.171? So we now have a full YouTube video on juvenile delinquent data that walks through the juvenile delinquent data section, which is Minnesota Statute Section 260B.171, and its application. It's called Law Enforcement Data on Juveniles. So if you'd like to take a look, you can go to our YouTube page and search for that video. Generally, for a juvenile to be subject to 260B.171, this section says that juveniles must be delinquent or have been engaged in a criminal act. This requires some suspected wrongdoing by the juvenile or something more than just being a witness or a victim to an action. The juvenile does not need to be convicted or charged for this section to apply, but must be identified as engaging in some sort of action that could be an offense. So some sort of wrongdoing. It's important to highlight here that 260B.171 applies to juveniles who are or may be delinquent. So that may be delinquent is the phrase that we rely on, where they don't need to be convicted, they don't need to be charged. It's just there has to be some wrongdoing that juvenile has engaged in. They have to be suspected as some sort of alleged bad actor. If the juvenile is delinquent or may have engaged in a criminal act, Minnesota Section 260B.171 requires that all records on juveniles who are or may be delinquent or may have engaged in criminal acts be kept separately from adult law enforcement records. So if you maintain data that may have originated in another agency but is a juvenile record, it should be maintained pursuant to 260B.171 subdivision 5A. Juveniles who are merely victims or witnesses to crimes are governed under the regular law enforcement data section, which is in Minnesota Statute Section 13.82. There can be protected identities for those individuals, but it's not automatic. So that's when you'd reference 1382 subdivision 17 to determine if there's some sort of protection for other juveniles who are not delinquent involved in those law enforcement actions. All right, our next question here. A government entity's data access policy states that they will respond to my data request within 14 days, but they haven't responded. Has the entity violated the Data Practices Act? So generally, entities should be following the policies and procedures that they adopt, as data requesters rely upon these policies to submit data requests to the government entity. The Data Practices Act, at a minimum, requires entities respond to requests from a data subject within 10 business days and requests from members of the public within a reasonable amount of time. So we encourage entities to note these requirements in their policies, and then if the entity chooses to set additional timeframes within the policy to ensure those additional requirements can be met. So entities should be following the processes that they put in place. The time frame for response for a public data request is flexible, likely to accommodate the potential for large data requests. If an entity would like to include additional response requirements in its policy, such as a 14-day response or some other option, you might want to include something that would just indicate that the entity is acknowledging receipt of a data request within a certain period of time and provide updates on the status of the data request at certain intervals. Our next question is, should community service officers be redacted from inactive body camera footage? So Minnesota statute section 13.825, which is cited at the bottom of the slide here, governs body-worn camera data collected by a peace officer. Generally, inactive body camera data are private. This section indicates that on-duty peace officers may not be redacted unless they're undercover. Here, the non-sworn community service officer is not a licensed peace officer, and the facts don't indicate that one of the public exceptions to the body camera data's private classification applies. So yes, you would redact the non-sworn community services officer's image and voice that appear in the body camera data unless they provided written consent for somebody else to have a copy of that footage. The non-sworn CSOs are treated like any other civilian data subjects. So as a note with this one, this question applies to body camera data, which only includes body cameras that are worn by a peace officer. So if the facts of this question were changed and the non-sworn CSO was wearing the body camera and collecting the data would not be subject to 13.825 and instead would be governed by the regular law enforcement data section, which is 13.82. So it matters who is wearing that body-worn camera, as 13.825 only applies to body cameras worn by a peace officer. Another question that we've been receiving, what must law enforcement agencies disclose in response to background check requests? So generally, law enforcement agencies have an obligation to provide public data in response to a background check request. Any private data with written informed consent from a data subject can also be released. If the law enforcement agency wants to provide confidential, active law enforcement investigative data, it could make a determination under the public benefits section in 13.82 subdivision 15 if that agency determines the access to that confidential data will aid the law enforcement process, promote public safety, or dispel widespread rumor or unrest. So as a note, there are some agencies that have statutory obligations to perform background checks of certain individuals. However, a statutory requirement to perform a background check is not necessarily statutory authority to share not public data from the entity who's maintaining that data. There needs to be a statutory sharing authority that explicitly states that the entity maintaining the not public data has authority to release that not public data to a recipient. So we're frequently asked whether law enforcement agencies can release body camera footage in response to a background check. Inactive body camera footage is generally private under 13.825. So as a result, body camera footage can only be released with written informed consent authorizing the release of this private data to the recipient. Okay, another question here. Are the judicial and legislative branches subject to the Data Practices Act and the Open Meeting Law? The answer is no. Only the executive branch of government is subject to the Data Practices Act and the Open Meeting Law. So for the Data Practices Act, these entities are state agencies, statewide systems, and political subdivisions. Minnesota statute section 13.90, subdivision 2, which is cited on this slide here, explicitly states that the judiciary is not governed by the Data Practices Act, and access to data maintained by the judicial branch is governed by rules adopted by the Supreme Court. So for the open meeting law, these are public bodies, The public bodies that are subject to this law are meetings of a state agency, board, commission, or department when they're required or permitted by law to transact public business in a meeting. The governing bodies of school districts, counties, cities, townships, unorganized territories, or other public bodies are also subject, as well as the committees, subcommittees, boards, departments, or commissions of a public body, and the governing bodies of certain statewide and local public pension plans. So there is a list for those bodies that are subject to the open meeting law. That list is in 13D.01. So if you're unsure of whether your public body is subject to the open meeting law, I'd go to that section. You can always give us a call and we're happy to talk through the application of 13D.01 and the open meeting law. There are certain groups or public bodies that also explicitly state they are subject to the open meeting law in their enabling legislation. So that would be the first place to start if you're curious as to whether your group is subject to the open meeting law. Okay, so those are our questions for today. Let's take a look at some of your questions. You can send those in to the panelists so we can make sure to see them. If we're silent here as we're going through the questions, it's just because we're reading them, and we will get to your question as soon as possible. Thank you.
Okay, the first question that we have popping up here is what Data Practices Act provisions control sharing of law library clinic requests? The law library requests contain requests for legal advice, but are routed to volunteer attorneys via law librarians. And so that really gets to the answer that Katie was answering in question number 7. You know, the law library falls within the judicial branch. And so the state law library and the county law libraries are not going to be subject to the Data Practices Act. You know, that's specifically stated in 13.90, that judiciary exemption. Really, those sharing of those requests and different things like that are going to be governed under the access to data rules that are adopted by the Minnesota Supreme Court. So if you have some questions about that, I certainly recommend reaching out to the court administrator's office or to the law library and the law librarians themselves, and they might be able to answer that question for you.
Okay, we have another question. And if a police department outsources their dispatch function but captures the CAD dispatch data as part of a police report, what is the classification of the CAD comments? I'll be honest, I'm not good with the abbreviations for CAD, but I can say if you're outsourcing any dispatch functions and capturing, you know, those comments as part of the police report, you're going to be looking at 1382 for the classification of that data. Even if it's outsourced, you know, they're performing a government function and then you're maintaining it as part of your law enforcement data. So 1382 would apply to the data. So if the comments are aligning with the public data that's listed in 1382 subdivisions 2, 3, or 6, it's just going to be public. Otherwise, it will be classified under 1382 subdivision 7. So depending on the status of the investigation, it could be confidential or public if the investigation is inactive.
We have another question here about remedies. So the question asks, in cases where a government entity wrongly denies access to public data and is non-responsive to appealing their decision, is there any recourse other than seeking an advisory opinion? And with advisory opinions, is the $1,000 fee retained by the Department of Admin? Is there any reimbursement by the entity that made a wrong decision? So I'm just going to start with what happens when a requester disagrees with an entity's determination. The first step is to go back to the entity and try to see if you can communicate with their data practices compliance official about the response that you received. You can always reach out to our office informally. So we provide technical assistance and answer questions about this law, and we can answer questions about data requests. And in some cases, we help facilitate responses and communicate between government entities and data requesters. So you can always reach out to us. As far as advisory opinions, the advisory opinion process is a non-binding process where anybody can ask a question to the Commissioner of Administration. The Commissioner of Administration has discretion as to which advisory opinions are accepted based on the facts of the opinions and whether there is something that she can state in response to those advisory opinion requests. But there is no fee for an advisory opinion. The $1,000 fee is actually through the Office of Administrative Hearings. So there are a few different remedies available if you disagree with a determination made by a government entity or a response to a data request. The first remedy is in Minnesota Statute Section 13.08. That section says there are actions to compel compliance that can be made in district court, actions for injunctions that can be made in district court, and there can be various penalties and remedies as well in 13.09. However, that $1,000 filing fee that's referenced in this question is through the expedited administrative proceeding at the Office of Administrative Hearings. And so that is only an action to compel compliance. There is a data practices complaint form on the OAH website that has some information about submitting that sort of complaint with the Office of Administrative Hearings. If the person filing with the Office of Administrative Hearings substantially prevails, they do get their $1,000 or they do get their money back. But you have to substantially prevail in order to be reimbursed. I hope that answers your question.
Okay, the next questions that we have here are going to be related to law enforcement data, where we've got a requesting party who asked for a copy of the police report by number and then identified that they are requesting the data about which his wife was a victim of the crime, and the crime was sexual assault. The data is inactive criminal investigative data. And really the question here is, what is the appropriate response? So that's a great question. And so this kind of gets into the protected identities under 1382 subdivision 17. One of the protected identities is victims of CSC. And so occasionally somebody will submit a data request where they reveal one of those protected identities. And one of the things that you do need to keep in mind is that the way the data request comes in does dictate your response at times. And so in those situations where data request identifies someone with a protected identity, really the appropriate response is there is no data responsive to your request. So this question, the person who asked this question, your feeling on that is right. If the data request reveals that protected ID or something like that would reveal not public data about that individual, there is no data responsive to your request is appropriate. Mostly because there would be no way that you could redact enough information out to continue to protect that person's identity. Really, the requester could take a look and say, hey, I don't see my wife's name or that protected identities person's name anywhere in this report. They must be a victim of CSC or have some sort of other type of protected identity. So really the appropriate response is there is no data responsive to your request in these sorts of situations. Oftentimes, under the law, you are required to cite a statutory section that explains why you're withholding data. You can't do that in this because, again, that may reveal something about the nature of the protected identity. So maybe a good suggestion on these types of things or these types of responses is to say, you can contact the data practices office with more questions, or you can ask them about this response, and then we're certainly happy to have that conversation with that requester just to simply say, oh, if you identified someone whose identity is protected, that may be dictating the entity's response, and we can encourage them to send a new request where they aren't identifying someone or just asking by the police report number. If they're simply asking by police report number and say nothing else, then I think you can still provide access to those data, redact all of that information out. But anytime a protected ID is identified in the data request, there is no data responsive to your request is probably the appropriate response.
All right, we have another question here. This question asks, in cases where law enforcement officers obtained from a non-witness or non-party something like ring camera footage using a flash drive, and the law enforcement agency makes a copy of that footage, then goes to return the flash drive, is the original footage now government data? So the data that are maintained by the government entity are, right? So the data that are maintained at the law enforcement agency, that copy that the law enforcement agency has, that person who owns the ring camera has no obligation to respond to a data request. They're a private citizen. They're not subject to the Data Practices Act. But the data maintained by the law enforcement agency when they made that copy and brought that into their investigative file are now government data. And so when that case becomes inactive, that video footage is just treated like regular 13.82 data. And so you would review to see if there are any protected identities or any reason that a redaction would be required, but generally inactive law enforcement data are public, so that ring footage would likely become public in the hands of the law enforcement agency once that case becomes inactive. We have a couple more minutes here while we wait to see if you have any additional questions for us. I'll just note that the slides are available at the link on this slide, so you can download the PowerPoint on our website there. And a recording of the webinar will be posted on our YouTube page in the next few days. Our polling panel isn't working today, so unfortunately we aren't going to be able to put our evaluation out there, but hopefully we'll be able to do that next time. I'll hang out here for a few more minutes and see if any additional questions come in. Okay, here's another question. It says, I'm not sure if this says associate email subject to the Data Practices Act, school, city, county. So any data maintained by a government entity in some sort of physical format are subject to the Data Practices Act. So if somebody sends an email to the school district, the city, the county, the data in the hands of the government entity are government data. And then the government entity has an obligation to make a determination on whether there's a classification that applies to those data. And so an email itself generally doesn't have its own classification. Who has access will be determined by the content of those emails. So what the email is about. Maybe there is a parent emailing the school about their student, and so the data might be 1332 data, private education data about the student, or maybe there's a property complaint submitted to the city, and so it would be private, or it would be confidential property complainant data under 13.44. But emails to a government entity are generally subject to the Data Practices Act when maintained by the government entity. It's just the classification that might vary. All right, we have reached our time for today. So if you have sent a question in, we will be sure to get back to you if we haven't already. Thank you all for joining us. Keep an eye out on our website for any future webinars. If you're not already signed up for our Gov Delivery notice for upcoming workshops and webinars, you can do so on the bottom right-hand corner of our website. And as always, please feel free to reach out to us if you have any questions. Thank you for joining us, and I hope you have a great day.